Well, I know it's a busy Monday morning, so I think we should probably get a kick-off. Thank you all for weathering the rain and making it here in a relatively dry fashion. My name is Tim Wilson. I'm Australia's Human Rights Commissioner, and it's a great pleasure to be here to launch the Rights and Responsibilities Consultation Report, which of course has the title 2015, but the consultation was actually conducted in 2014. So that's the reason why we've chosen this year, because we've chosen to launch it this year. I'd like to begin by acknowledging the enduring cultural connection of the Gadigal people of the Eora Nation and the land which we meet on today. I'd also like to acknowledge the Honourable Philip Ruddock MP, Federal Member for Barrowa and Chair of the Parliamentary Scrutiny Committee on Human Rights. And in addition to that, as people keep reminding me, the Father of the House of Representatives. I'd also like to acknowledge Professor Rosalind Croucher, the President of the Australian Law Reform Commission, who has decided to sit bang right in the front row so that I couldn't miss it. Thank you, Ros. To my good friends and colleagues, the Aboriginal and Torres Strait Islander Social Justice Commissioner Mick Gooder, to Susan Ryan, the Age and Disability Discrimination Commissioner, welcome to both of you and to the rest of you who have come along today. It's a great pleasure to have you here. And it's a great pleasure to be able to launch this, a copy of which you have in front of you and will be available, I'm sure, on the website shortly, the Rights and Responsibilities Consultation Report. Like my Commissioner colleagues, the role of the Australian Human Rights Commissioner is to look at systemic public policy issues. No Commissioner investigates complaints from the public. That's a great common misconception. That is the role of the President. On my arrival, the President and I actually divided policy responsibilities in the human rights space. The President took international and asylum seeker issues. I took domestic, civil and political rights as my focus, and that's the subject of the themes that were covered in our report. The Act that establishes the Australian Human Rights Commissioner, appropriately titled the Australian Human Rights Commission Act, gives this office little statutory power. The power of the office is to bring together parties and prompt conversations that may not otherwise happen, and to shine a bright statutory light into dark places and corners across Australia. Ordinarily, the Human Rights Commissioner is appointed with modest attention and given breathing room to develop their own agenda. I wasn't afforded that luxury. Since being appointed, I have been developing two significant work programs. The first is in the human rights space. The second is as de facto Commissioner for Sexual Orientation, Gender Identity and intersex status issues. There has never been a Commissioner that's taken on this latter important role before. And as many of you who will understand and know the Commission's structure, it does not fit directly within another Commissioner's portfolio, and they are not responsible for this task. But today we're going to talk about human rights. When I took on this office, I understood what it meant to be Human Rights Commissioner. What I probably hadn't properly thought about was the Australia bit. As you know, I am not short of an opinion, but opinions aren't enough. You can't do this job without getting out of Pitt Street and hearing directly from Australians. So that's what we did. And by we, I don't just mean myself, but my Commission staff and colleagues, Louise Bygrave and Siri May. To action both roles, both as Human Rights Commissioner and as SOGI de facto Commissioner, we held two parallel national consultations throughout the second half of last year. The Rights and Responsibilities Consultation asked Australians what issues matter to them amongst the core of the liberal individual human rights and freedoms: freedom of speech, freedom of association, religious freedom, and property rights issues. But we welcomed submissions on any other things that people thought were relevant or appropriate. We also are still holding our ongoing SOGI consultation. The SOGI consultation is primarily focused on ensuring government programs that have an impact on people's day-to-day lives, such as health and education, treat everybody fairly and equally under the law and by government. The report for that consultation will be released shortly. So to commence the Rights and Responsibilities consultation, off the back of our free speech symposium in August last year, we released a consultation paper and a survey. We received 68 written submissions and 991 survey responses. We also held numerous targeted meetings, as well as 13 public meetings in Adelaide, Alice Springs, Darwin, Canberra, Perth, Cairns, Charters Towers, Brisbane, Singleton, Sydney, Hobart, Melbourne, and Lorne. There have been some who have recently argued that the role of the Australian Human Rights Commissioner is defunct. If you can ignore the obvious absurdity that thinking that the Commission can achieve its primary purpose without an official individual charged to advance its core purpose, the practical experience we had in those consultations around the country is that Australians value the opportunity to talk about human rights. There was a strong interest in talking about the necessity to preserve individual human rights in 21st century Australia. What became clear in the different fora we held was how keen many people wanted opportunities to raise human rights issues that affect them, their friends, their family, and their community, and for it not to be rolled into partisan political debates. It was a reminder of the importance of the Human Rights Commissioner office, regardless of who is serving in it. It's easy to think human rights are not political, but they are political ideals reflecting political values developed by political philosophers and are entrenched in political instruments. Human rights have and always will be, to a certain extent, political. It's for this reason we deliberately also consulted political parties, or more to the point, members of them. Political parties are often the place where you will find people interested in human rights. We wrote to major political parties and actively sought their input, including the opportunity for them to host events for their members. And I'm happy to say they took those invitations up. We met with the Leader of the Opposition in Western Australia, a Greens MP in South Australia, and Young Liberals State Council in Brisbane, to name but a few. And they all raised insightful and important issues. In addition to the consultations, we had the generous support of some groups who contributed case studies to give life to the policy ideas that we were exploring. And I'd like to thank the following groups for contributing their case studies. The AEMIA Digital Policy Group, whose case study focused on how internet companies were ensuring the preservation of free speech with responsible discourse in social media. And I'd like to acknowledge Melina Rohan from AEMIA, who's here today. United Voice, whose case study focused on how the right to free association was not enough. It also required the freedom to exercise it. To Adelaide's Hutt Street Centre, whose case study focused on the role of civil society to improve people's skills and capacity for economic and social participation, and utilise the most important property right of all, and the one that is available to everybody, people's physical body and their intellectual property. The Yarruru native title holders, whose case study focused on the legal and regulatory restrictions on the freedom to exercise property rights following native title determination. And Ninty One, who provided a case study looking at the importance of intellectual property to the advancement of Aboriginal Australia's interests. Now, I want to make it clear that we did everything to keep the costs of these consultations down while ensuring we had maximum reach. I think some journalists thought we wouldn't be mindful of these costs. So we received a series of freedom of information requests on the costs of the consultation. To remove any ambiguity, the expenses incurred for the 4 months of consultations across the whole of Australia was $32,169.21. I don't know what the 21 cents was for. We achieved a national consultation at such a low cost because we worked with community organisations that hosted us and community consultations. And I would like to extend my thanks to all of them for their logistical support, their preparedness to host us, and to work cooperatively with the Commission. While we spent months on the road, we had to keep, of course, on top of and participate in the many debates around the nation that were concurrent, including free speech reforms, extensive discussion around national security legislation, and another one, for example, was the need for respect for transgender Australians. Throughout the consultations, we had some lows. Sadly, a poor bird got the short end of life's stick as we tore down the road from Fitzroy Crossing to Derby and sadly flew into our windshield. So I'd like to pay acknowledgement to that tragic death. Discovered things about ourselves, including a love for snack-sized cucumbers. But the consultations were almost insane and filled with stories of ordinary Australians taking extraordinary action to improve the welfare, the rights and the freedoms of their fellow Australians. Our first stop was in Kununurra, and we met with Ian Trust from the Woonan Foundation. Trust and Woonan work to advance the social and economic welfare of their local Aboriginal community. Trust does his work without drawing attention to himself in the national spotlight, but clearly understands that welfare gains come from the development of community, expectation, responsibility, and mutual support. We met trailblazers like Peter Ferguson. Peter is a transgender woman that runs a small non-profit organisation called Brain Injury Matters. Off the smell of an oily rag, Peter's primary task is to raise public awareness about acquired brain injuries. Her organisation provides support and assistance to those that have an ABI to assist them in living a full and productive life. We met the wonderful people at the refuge in Alice Springs that were seeking to provide support to women facing domestic violence and helping to improve understanding and awareness about the unique challenges faced by transgender Australians and intersex Australians in remote communities. Perhaps my favourite meeting was with a group, and they'll remain nameless, that organises solely for the purpose of promoting compassion toward a marginalised section of the community, yet, strangely, quickly highlighted how they work around anti-discrimination laws for people who don't quite fit in to their worldview. Compassion clearly still remains very much in the eye of the beholder. And at just about every public event, representatives of the Scarlet Alliance, which is the Sex Workers Industry Association, turned up to ensure that I had heard their concerns. I presume there is a representative in the room today. It would be ironic if they were not. So if you are to the representative of the Scarlet Alliance, I want you to know I have heard you. But as you know, most of the issues you face are at a state level. I admire your persistence, and you have highlighted to me the problems that you face from a human rights basis, but more importantly, how they then have a human and health consequence. Systemic issues that exist across the nation are very real in human rights. Increasing restrictions on free speech, from overly generous defamation laws to free association through anti-consorting laws, do limit people's human rights and the freedom to exercise them. The objective of these laws is, of course, not in dispute. People have a right to their reputation and to be free of gang-related violence and crime. But what is disturbing is that in an effort to tackle illegal mischief, law is being used beyond its purpose and its place. Governments are making the exercise of basic rights unlawful in place of actually punishing a legitimate crime. You can read through the panoply of issues Australians raised with us in the report. We've identified the problems. The next 4 years will be dedicated to working to address them. First is to improve the poor understanding of human rights in Australia. Australians do care about human rights, but not in isolation. They care about them nested within a broader framework of other ideals, such as fairness and justice. But there is a poor understanding of the story of human rights and freedoms from ancient liberties to Magna Carta through to the present day. This year, and I know you're all excited about it, is the 800th anniversary of Magna Carta. But this important anniversary provides a catalyst to improve this understanding amongst the next generation of Australians. In grade 6, students are taught about Magna Carta. In year 10, they are then taught about the Universal Declaration of Human Rights. But in between these two bookend important events is the story of revolts, revolutions, liberal intellectual inquiry that took the Western world from political and social repression and economic subsistence to prosperity, pluralism, democracy, and freedom. That story has an extremely important role in ensuring that Australians understand where we've come from and to inform their thinking about where we are going. To start addressing this gap in education, the Commission is currently developing educational resources to tell the story of human rights and freedom to educate the next generation of Australians. The 800th anniversary of Magna Carta will be the launchpad of these resources, but it is very much our intention that they will be used by schools every year thereafter to continue the education process. Freedom of speech remains a key issue, ranging from restrictive state-based defamation laws to, of course, the ongoing debate around Section 18C of the Racial Discrimination Act. The lesson of the government's botched efforts last year to reform the latter law demonstrates the problems of reforming free speech laws that are overly restrictive, without proper concern, firstly, of the need to explain the problems with laws, needing to listen to the concerns and properly factor in those concerns in any proposal for reform, and also a broad consensus for reform that needs to be proposed. Despite the rhetoric of a freedom agenda, presently the necessary political and social environment does not exist to drive reform in government. But I will keep working to ensure that there may be one. The tension between religious freedom in a pluralistic nation and a secular state is an issue that bubbles under the surface of political debate that must be addressed. So today, I formally announce that we will be establishing a Religious Freedom Roundtable at the Australian Human Rights Commission that will meet in the second half of this year. We are currently designing the structure, participation and parameters of the roundtable to advance religious freedom and its interaction with public policy. The purpose of this roundtable will be to listen to religious communities, their concerns, and seek as near as possible a consensus about how best to advance religious freedom and its interaction with public policy in 21st century Australia. I'm elated at the extremely warm and positive response a Religious Freedom Roundtable has received from Australia's religious leadership and communities in the meetings that I have held to date, and their enthusiasm to open an ongoing and constructive dialogue that is mindful and considerate of their concerns, while recognising that the Commission equally has a responsibility to ensure all citizens are treated equally and fairly by law and government. As announced in my National Press Club speech, property rights issues have consistently been raised with my team. During my Press Club speech, I announced that the Aboriginal and Torres Strait Islander Social Justice Commissioner, Mick Gooda, and I will be co-facilitating a high-level roundtable on the freedom to exercise post-determination property rights for native title holders. And today, I'm proud to announce that this high-level roundtable will be held from Tuesday 18 to Wednesday 19 of May in Broome this year. Invitations for this high-level roundtable have now gone out and it has received an extremely positive reception. I'm acutely mindful that the Australian Law Reform Commission is about to release its review into native title. This process will be very different from existing reviews of native title, and by that I mean our process. Our interest is solely at the legal, regulatory and policy flexibility for Aboriginal communities to fully exercise their property rights. I need to stress that while Commissioner Gooder and I will co-facilitate this important event, it will be led by Aboriginal Australians for the benefit of Aboriginal Australians. Any proposals from this reform and fora will require the consent of native title holders if implemented and will not seek to compromise the protection of the inherent legal rights of Aboriginal Australia. While it was not initially canvassed in our consultations, the effective arbitrary detention through the denial of liberty through the use of restrictive practices for those in mental health care came up regularly. I am also going to focus on these issues later in my term of office once we can establish the parameters. Now, I've spoken a lot about rights, but rights also come with responsibilities. Throughout the consultations, Australians were deeply mindful of the fact that more energy needs to be directed toward building a culture of responsibilities. Some argued we should even have a charter of responsibilities to set out the expectations of the observance of rights. I should add that I disabuse them of this notion. In our consultations, we asked for evidence of where communities were building a culture of responsibility. To be frank, little information was provided, but in many ways I am not surprised. The practical reality is that the mechanisms we use to promote a culture of responsibility is informal and not directed by government or bureaucracies. A culture of responsibility comes from the values we are taught when we are raised from our parents, friends, role models, school and religious institutions, among many. The norms we establish in society and the expectations of normal human decency. Outside of the formal responsibility that comes with schemes like insurance, responsibility cannot be imposed by government through law or regulations. An understanding of responsibility has to evolve. Many people raised with us concerns they had about the way people used and abused technology, and particularly the internet and social media. The internet is, of course, a wonderful expression of one of humanity's greatest achievements, but it also contains the sewer of some of our worst and most primal instincts. No one innovates to advance uncivil conduct, yet that is what sometimes the internet is being used for. When Twitter was being developed, I doubt anyone thought a community of anonymous trolls with the sole purpose of being digital wreckers would necessarily evolve. Many people argued we need stronger legal protection against this community or others that leverage social media for uncivil conduct. But what is equally obvious is that the problems of technology are best addressed by technology itself. Companies organically develop their own policies to respond to the problems that appear online and are both more capable and responsive than government ever could be. While we regularly look for firm and structured ways to advance a culture of responsibility, it almost always needs to be advanced through a responsive and informal culture of mindfulness for others. And that is what we are slowly seeing, though I recognise for some people it can be frustrating along the way. Finally, I just want to give some thanks. Thank you to Lucian, who organised the consultation tour, to Simon, who did the bookings, Siri, who provided the snacking cucumbers, and organised the parallel SOGI consultations, which will be released shortly. But I also need to strongly thank Louise Bygrave. Louise is the Commission's Senior Policy Advisor on Human Rights. More importantly, she was delegated the task on my arrival as Human Rights Commissioner with, as some people put it, the poison chalice, to help me with my work, to listen to my rants and find the inner strength to sometimes tell me no. Louise designed and ran the consultations, wrote the report and put up with my occasional mood swings after months of too many days on the road, not enough sleep and botched flight bookings. She even learned to love Google Maps as much as I do. Thank you, Louise, and the whole team for your support, and the launch of this report marks the beginning of our work, not the end of it. Thank you very much. There you go, officially launched. I'm happy to take questions if anybody's got them, otherwise, or have I scared everybody off on a Monday morning? Yeah.
Recently, sympathy for
Well, I didn't talk specifically about Senator Leyonhjelm's bill. What I talked about was welcoming and the renewed debate around this issue. You know, one of the things that I need to stress is if you think about liberal and conservative principles, philosophical principles, I mean, arguably the highest of those principles is equality before the law. And I find it objectionable that we have laws that seek to discriminate a particular group and provide special legal privileges to another group. And so I have made it clear that I believe the law should be changed, and it should be changed promptly, at least because when you use the power of the state to change society, you are engaging in social engineering. Yet equally, when you use the power of the state to restrict societal change that has already occurred, you are equally engaging in social engineering. The time for this issue has come, least so that we can legislate for it and move on. But in terms of the substance of your question, the challenge and the test is there is a philosophical difference between a civil celebrant and a wedding cake maker or something along those lines. The difference is the civil celebrant is licensed by the state to provide a civil service. It's extremely important that they do so without discrimination. But we have this tension again, and this is why we're going to set up a religious freedom roundtable, to talk about how do we advance these important principles while achieving equality before the law, and whether we can design laws in a way that is fully mindful of both policy objectives. So I've proposed, and I'm not suggesting it's a solution, but we talked about a lot on the road and canvassed with different sections of the community. Could you, for instance, change the law so that when people seek to be licensed as civil celebrants, that they may nominate, voluntarily I might add, nominate that they choose to marry heterosexual couples or homosexual couples or both. And then you wouldn't need an issue if somebody was a licensed civil celebrant who had a personal religious motivation to be in the position where they were discriminating against somebody simply because they would not lawfully be able to provide that service to someone. So what I'm looking at is how do we manage the tension between these things and these issues so that we can advance religious freedom and equality before the law. Because to be quite frank, if you're making cakes, last time I checked, nobody actually bothered wondering what the purpose of making that cake was for. It doesn't really matter what the substance of it is. There's absolutely a degree and a difference between civil celebrants and wedding cake makers. That's an easy question. Go on.
In this year of Magna Carta, is the Commission
You ask this question at every event you come to, and so that's why I welcome it. Will that focus in the work that we're doing as part of Magna Carta 800? Annie, in case you don't know this, the answer is yes, in terms of the importance of trial by jury and why it was established. But are we going to look at it as every part of our work throughout this year? I've listed my priorities because unfortunately as an organisation we have scarce resources and I, as a commissioner, have time, and that is going to be the focus of my work. But is trial by jury going to be some of the work we're doing? Yes, it's going to be included as part of our educational resources, and when it contextually comes up through procedural fairness, it will also be addressed. Thank you. Oh, well. all very relaxed on a Monday morning. Thank you for everybody for coming. And if you want to discuss anything afterwards, I'm more than happy to chat to you. Thank you all for coming.